Welcome and thank you for joining us for today's presentation, Trade Secrets, Protecting Assets and Managing Risk. We have just a few announcements before we get started. Please note this seminar and all of the accompanying materials are protected by copyright and that the material presented by our speakers at this program has been gathered for general informational purposes only. The entire program is being recorded by Fox Rothschild and the recording of any part of this presentation by others is not permitted. You can submit questions during the presentation by utilizing the question and answer tab in your WebEx screen, and our presenters will do their best to answer as time allows. Without further delay, I will hand it over to Michelle to give a brief introduction.
Hello, everyone, and welcome to today's talk, Trade Secrets, Protecting Assets and Managing Risks. My name is Michelle Romer-Schoen, and I'm the Events Manager at Princeton Innovation Center BioLabs. Princeton Innovation Center BioLabs opened for business in 2018 with the mission to foster innovation, collaboration, and entrepreneurship in New Jersey. We have over 30,000 square feet of laboratories, meeting rooms, offices, and co-working space, and we are here to make it easier for new science-based companies formed by Princeton University faculty, students, and alumni, as well as members of the wider New Jersey community to get started and grow. Now I would like to introduce you to Jerry Norton, Managing Partner of Fox Rothschild's Princeton office. Fox Rothschild is a long-standing sponsor of Princeton Innovation Center BioLabs, and we are grateful for their continued support. Jerry will introduce you to the speakers.
Thank you, Michelle. It's a pleasure to see everyone today, virtually. I want to introduce two of my law partners in the litigation department, Brian Berkley and Eric Reed, today's presenters on this important topic. Brian is a graduate of Bucknell University and a cum laude law degree from Washington and Lee University School of Law. He was also a member of Law Review. Eric Reed graduated from Alma College with the Bachelor of Arts in summa cum laude, and he has a law degree from the University of Michigan Law School. Not only are Brian and Eric really smart gentlemen, they're excellent trial lawyers, and they know what they're about to speak and educate us all on trade secret law. Brian and Eric, the floor is yours. Thank you.
Thanks, Jerry.
Thank you, Jerry. Let me pull up the slide deck here. So thank you, everyone, for joining us today. Good afternoon. Brian, you want to start off our talk today?
Yeah, thanks, Eric. So thanks, everyone, for joining us. As Jerry mentioned, we're going to talk about trade secrets. We're going to talk about the basics and give you some tips and thoughts on how to manage the risks and protect what is considered one of, if not the most valuable intellectual property of companies. So we thought we'd start by defining the value. And here are some data points that give you a sense of how valuable trade secrets can be. So, the first data point notes that trade secrets, the value of trade secret theft has been calculated to be worth almost 3% of US GDP, $682 billion. Surveys of companies at the C-suite level identified trade secrets as the most important IP. The data there also shows that at least from 2016 to 2020, and I expect this number has gone up significantly since then for a variety of reasons, damage is awarded in litigation relating to trade secrets has been calculated to be almost $1.3 billion. And we thought we'd give you the classic example, Coca-Cola, whose bread and butter is, of course, their secret formula that they've kept secret for over 100 years. And you see the numbers of how valuable that company at one point in time was, when we got these numbers a little bit ago. So that's the value. Let's talk about the risk, okay? So here's some other data points from companies that have been surveyed. They identify that 80% of the C-suite level execs recognize that trade secrets are critical to their business, but they identify that about a third of their trade secrets have been stolen in the last 10 years. But only a third, roughly 35% of those individuals feel as though they have adequate trade secret protection. 75% of them expect the risk of trade secret theft to increase. And I think that probably has played out given the pandemic, given the great resignation that is occurring. And as we'll discuss later, given that your former employees are one of the biggest pieces of risk to your trade secrets. And that goes to the next point. 90% of loss comes from insiders. Those are your former employees, your current vendors, your former vendors, anyone that you share your trade secrets with or have access to your trade secrets at some point in time. They represent a risk to you and your company. Here's a perfect example of what we're talking about. So a couple years ago, or now it's a few years ago, Uber self-driving truck subsidiary Otto was accused of stealing trade secrets from Google's autonomous driving sub Waymo. Case settled in February 2018, with Google being awarded $245 million equity stake in Uber, all while Google's sub was maintained its innocence. This gives you a sense of the scale of value that it can be attached to these type of cases and to trade secrets in particular.
So we find that giving these examples really help to illustrate the issues in play here, both in terms of what trade secrets are and how to identify the best way to protect them and make sure they are not exiting your business. Another example here is Leopard Solutions. They were a provider of data and analytics for law firms like our firm, and they sued a competitor, Legalist. They had given the world an opportunity to use a free trial period to access Leopard's database. Legalist took quite extreme use of that and downloaded nearly a whole database. And so there was a suit over that. There was an access agreement that limited what you could do with that access, and that was fully, at least as was claimed in the case, fully disregarded by Legalist.
So we've talked about the value, we've talked about the risk. Now the rest of the presentation is really going to focus on the solution, all right? And we're going to break this up into two buckets. Bucket one, we're going to talk about pre-litigation protection strategies, things you can do right now to protect your trade secrets. We're then going to focus on, because we're both litigators and we love, talk about litigation, we're going to talk about litigation tools. And in particular, we're going to focus on what's called the Defend Trade Secrets Act. That is a reference to a federal statute that was passed in May of 2016 that focuses on nationalizing the trade secret protection. And before the passage of that act, you had to focus on what states were, how states protected trade secrets, which are still important and still in play. But the Defend Trade Secrets Act now is federal, and it gives you, as we'll discuss in more detail, access, among other things, to the federal court system. So Eric, you want to jump onto the trade secrets? What are they?
Sure. So one of the most helpful aspects of the Defend Trade Secrets Act is that it really broadly defines what could qualify as a trade secret. It really could be darn near anything, so long as it is one secret, and as part of being a secret, if you're claiming something is your trade secret, you would have to establish that you have taken reasonable measures to maintain that secrecy. And then you also have to show that the secrecy itself has value, that what you claim is your trade secret actually derives economic value because it is secret, because other people do not know what it is. So long as you check those three boxes, I've given some broad categories here: financial information, business information, perhaps more important to, or particularly important to this audience, scientific information. So your test results, your test methods, your R&D type information, that under the right circumstances can qualify as trade secrets. Some other examples here, we have broadly stated here. We don't need to go into all of these things. Some of these examples will be discussed in some of these categories rather will be discussed in some case examples that we'll discuss down the slide deck a little bit. But one thing I wanted to flag for you here is know-how. You see how we have a mark there. general know-how, an employee's knowledge about how to go about developing a product or a process, or doing the work, as generally stated. Generalized know-how is typically not protected as a trade secret. It's a bit of a gray area. It will play out in again, some of the examples that we'll discuss, but it is somewhat of a wild card in trade secret litigation. On the one hand, if you've taught someone and invested time and effort into training someone how to do a function or a task that is specific to your organization, you might be able to protect that know-how as a trade secret. But again, if it's something that's more generalized and common throughout the industry, you likely will not. Brian?
So Eric is giving us a flavor for what trade secrets are. What is, of course, just as important is what are they not? And Eric and I can probably tell you multiple stories independently as well as jointly on cases we've worked on together, where this is a significant and the first and one of, if not the most important conversation you have with a client, which is figuring out, okay, what trade secrets do you have and what are they not? Because sometimes folks think what they have is a trade secret, they find out later to their chagrin are not. So the first thing, trade secrets are not inadequately protected trade secrets. So going back to Eric's earlier slide where he defined the 3 bullet points of what you need to meet in order to have a trade secret. You've got to protect it. It's got to be a secret. You've got to make sure you've got the tools and the systems in place to keep it under wraps. You also have to make sure it has value, of course, right? So you have to make sure that you have done what you need to do to protect the secrets. What's not a trade secret? Publicly available information. So one of my more favorite examples of this is a recent case. For those baseball fans out there, you may be aware of the Astros sign stealing saga that took place a few years back, where the Houston Astros were accused and found guilty of stealing signs of pitches, what pitches to throw that the catcher typically sends to the pitcher. One of the pitchers that was a victim of the Astros sign stealing brought litigation and said, look, they stole my trade secrets, and as a result, it ruined my career. I had a terrible game that day, and it torpedoed my entire career. The case got thrown out rather quickly, and it did so because the court basically said, look, this is not a trade secret. While it may have been protected from or supposed to be protected from the Astros, any fan who was sitting in the right chair with, the right seat with his binoculars could see the signs. So that was not a true secret. So even though it was supposed to be secret as to the Astros, because it was publicly available, it didn't qualify as a trade secret. So I think that's a good example of what it means to say that publicly available information is not a trade secret. Reverse engineering. So if you're claiming a product is in the recipe or the way in which you made that product is a trade secret, and I can take that product when you sell out in the marketplace and I can figure out how you did it on my own, generally speaking, I mean, there's certain exceptions to this, but generally speaking, that's reverse engineering. And that means that what you took to make that product is not a true trade secret. There are some exceptions to that, some nuance that we won't get into in this presentation, but that's the general theme there. Next, contractually defined confidential information. So if you have a non-disclosure agreement, if you got a confidentiality agreement, those agreements have defined within them what is considered confidential information by the company. Oftentimes, those agreements have a larger definition for confidential information than trade secret. The point here that you should be taking away is do not assume, as everyone may know what happens when you assume. Do not assume that simply because your contract may have a definition for confidential information, that means that information as defined by the contract is necessarily also protected as a trade secret. Again, a little bit more nuance there that we won't go into, but the basic takeaway is contractually defined confidential information does not always equal trade secret. And then the last bullet point here talks about patents, and Eric's about to go over a little bit more of in detail the interplay between patents and trade secret. But here, just note that a patent's not a trade secret. And if you have a trade secret that you then patent, and once that patent's published, then it no longer can be treated as a trade secret. And the case cited here, Cajun Services Unlimited, highlights that point.
Yeah, and I'll pick that up. Just the short version of that is Cajun got into a litigation over an alleged misappropriation of a trade secret related to drilling technology, oil drilling technology. And they get pretty far down the path before the folks on the other end of that suit say, hey, wait a minute. A lot of what you're claiming is a trade secret appears in these publicly available patents. And to Brian's earlier point, that which is in a patent, a publicly available patent, is by definition not a secret. It's available to the public. That's part of the trade-off when you get a patent, is you disclose your invention to the world in exchange for a period of exclusivity. And so that caused an abrupt end, probably because should have happened a lot earlier than it did in that case. And that raises the next point. And in some circumstances, and you may be dealing with this in your own situations, businesses have to decide if they are better off seeking a patent for the intellectual property that is key to their business, or are they better off following the Coca-Cola path and relying on trade secret protection. And that topic is something that could be an entire seminar, but here we'll try to talk about some of the high-level considerations that go into that discussion and that thought process. The very first thing to think about, as we've alluded to already, is whether or not your intellectual property is in fact a secret. If it's not, you might not be able to patent it, depending on whether the prior art says and whatnot. But you're certainly not going to be able to get trade secret protection for it. Again, it can't be a trade secret unless it's a secret, and of course, it has to derive value from being secret. It has to have value because no one else knows what it is. That you are adding something to the market, you're using something in the market that no one else has access to. So that's one consideration. Another consideration is, even if it is a secret, how likely are you to be able to maintain the secrecy? So you have employees. Everyone has employees. Everyone has customers. Hopefully, if your business is developing along the path that you're trying to develop, you may be putting a product out into circulation. When you put that product out into circulation, as Brian mentioned earlier, depending on the product or depending on the process, you may be inadvertently disclosing your trade secret. Someone who knows, has some level of knowledge in your space may be able to reverse engineer your product, and then you could perhaps lose that trade secret protection if that was the path that you chose to, or the tool that you chose to protect your information. An advantage to utilizing trade secret protection is that your trade secret status can continue, theoretically, can continue indefinitely. Coca-Cola's trade secret's been out there for an awfully long time. Not out there, it's been utilized as a trade secret for an awfully long time. But you have to be able to keep the secret. Whereas in a patent situation, depending on the form of patent, you have a limited duration of that patent protection. I mentioned the reverse engineering issue. In a patent situation, if someone is able to reverse engineer your item, that's still an infringement. You can still sue that person for infringing your patent. The opposite is true in a trade secret situation. Again, if it's something that can obviously be reverse engineered by someone with even a modicum of knowledge in your space, that's likely not to qualify as something that would be a trade secret. So independent discovery is a way to, the ability to independently discover something is a way to defeat trade secret protection. Independent discovery or reverse engineering, not necessarily true in a patent situation. Another item to consider is, what is the demand in the industry? for your secret, your intellectual property? Is it something that you can expect to have widespread adoption? So if that's true, you might be able to license that. There is it's a lot easier to license a patent. Trade secret licensing is kind of a gray area of the law, but that's something to consider. And then finally, there are situations where your intellectual property, some aspects of your intellectual property may lend themselves to a patent protection, and others you may want to keep protected by trade secret law. An invention versus the method of producing that invention or something could be an example of that. Again, very broad strokes. These are the kinds of things that you might consider in deciding which path to follow to protect your confidential information.
Eric, before you go to the next slide,
Sure.
or talk about the next slide, there's a question that we have I think is pertinent to this area, and actually other areas of our presentation that I see here. So the question is, how can we understand the difference between a trade secret and general proprietary information / other intellectual property belonging solely to a company? Be interested in your thoughts. My initial thought on that is, going back to the basics, let's look at the definitions of the different types of protections or definitions of the property that you think may be in play for whatever it is that you're ultimately considering. So again, with respect to trade secret, I go back to Eric's 3 bullet points, right? Is what your talk is the potential intellectual property that you're considering, a recipe, sales information, etc. Was it a secret? Did you do things to keep it a secret? And is there a value that the company derives from it being a secret? And so those are the 3 things that you should be considering with respect to a trade secret. As far as the others, again, if it's a confidential information, it may fit those 3 definitions, but you also want to look at your contracts and see how they define confidential information. And then Eric just discussed a little bit about patents, and I'll let Eric, if you have any other thoughts on that question.
No, I would say just I think the single most important thing to consider there is this generalized type industry knowledge? I think the question was trying to distinguish generalized knowledge from something more specific that might be a secret. If it's generalized industry knowledge, excuse me, that's not going to qualify as a trade secret. If everyone in that space knows how to make a certain product, that the knowledge of how to make the product should not qualify as a trade secret. However, if you have a better way of making that product, if you have a way of making a product that has a greater efficacy or something like that, and there's something unique to the way that you do it that's different from how everyone else does it, that could qualify as a trade secret. So again, I told you that examples that we find are the best way to illustrate these issues. I want to give you, and this is kind of a lead into the next topic being the importance of identifying and knowing what your trade secrets are. And this is a little case study here. This is the Mallet case out of the Third Circuit, which is the federal appellate court for where we sit in Pennsylvania, New Jersey, and Delaware. And this was a case that involved release agents for commercial baking. So think of like your Pam spray or whatever that you put on the inside of your bread pans, but writ large. And what happened there is a rival hired a bunch of employees to over to their competing commercial bakery. And what happened is that they were able to accelerate greatly their development of a competitive baking release agent. Now, the original employer of these folks had done appropriate things in terms of having non-disclosure agreements, non-competition agreements, and taking other steps that would be objectively reasonable to protect their trade secrets such that it would otherwise qualify. And they had plenty of evidence of misappropriation. These folks who had left were not at all clandestine about how they went about taking the secrets. They were emailing right off the server to their personal email, and then they wiped their devices. And so, but the issue in the case became, what exactly is the trade secret? And so Mallet brings suit and there are motions to dismiss that suit right out of the gate. And the motion to dismiss is based on what the competitor claimed was just a failure to sufficiently identify the trade secret. They go through several rounds of pleading. Now, mind you, in litigation, this is months and months of litigation at great cost, and probably at great frustration to the plaintiff in that case. And finally, after revising and specifying how they articulate what the secret is in their pleading, the case goes up to the Third Circuit, again, the appellate court, and the Third Circuit says that even though that in this particular case the district court had enjoined the use had granted an injunction precluding the competitor from using these things eventually, that injunction did not specifically identify what the trade secret was. So the injunction, once it was finally obtained, the injunction itself got reversed and sent back down. So it was a very, I'm sure, painful and expensive lesson. But the takeaway is that you have to know what the trade secret is so you can build the right strategy to protect it. Another example is the Oakwood Labs case. This may be a little more applicable to this audience, but this Oakwood was a specialty pharma, and their particular expertise was in microspheres. And they had invested $130 million over 20 years of R&D into this microsphere technology. And they had explored a collaboration deal with an entity called Aurobindo. And that deal fell apart. And what Aurobindo did after the deal fell apart is they hired one of the lead people in the R&D space of Oakwood. And then Aurobindo, and this is all, by the way, we don't know anything about these cases other than what we read. We didn't have a role in these cases, but this is just what the published opinions are telling us. What the opinions state is that Aurobindo is able to then go to market within a year and with a $6 million spend compared to 20 years and $130 million spent on the original R&D on that same microspheres technology. And so, again, we have here a situation where they had to go through multiple rounds of amending their pleading in order to articulate what it was that was at issue. Really, it was design, how they went about designing the product, their R&D methods, what worked, what didn't work, and how do you particularly tweak your process to get what you need. All of those things were parts of the trade secret that were articulated. In this situation, after one of the several reversals by the district court, which is the first court you go to, the Oakwood takes it up to the Third Circuit and essentially says, help me out here. We've articulated this as best we can. This is what our secret is. We can't articulate it any more than we already have. And the Third Circuit looks at it and says, you know what, Oakwood, you're right. You did a sufficient job of identifying what is the trade secret. Aurobindo certainly knows what it is. By the way, one of the allegations in the case is that they had utilized a memo, despite the presence of an NDA, that they had actually utilized a memo that was provided subject to that NDA that disclosed some of the trade secrets at issue in order to accelerate that development, in addition to hiring away the talent. So that went back down to the trial court and was allowed to proceed. The lesson there, again, do the best you can to identify what exactly it is that you want to protect as a trade secret. So go ahead.
And just, again, just carry on to that. The definition, as you probably can see from these slides, is very flexible. And one of the earlier slides that Eric highlighted identified all the different categories of potentially trade secrets. He just went over a complicated pharma case, but you could have it as simple as a recipe for fig jam, as an example. It's a case that I litigated for, it was a $20 million dispute over the stuff you spread on crackers and whether or not that recipe was a trade secret. And Eric and I just recently litigated a case that dealt with customer lists and whether or not that's a trade secret and pricing information. So it's a very flexible definition.
Right. And on this slide in particular, what we're talking about, and again, this is pre-litigation, kind of the takeaway of the last two lawsuits that we discussed is that it's important for you as a business to understand what you claim as your trade secret. And there are multiple ways that you can go about doing that. One is a formal indexing of your trade secrets, a listing out of these are what we consider our trade secrets, and that would of course be put under lock and key within your business. And that might be something that you would do for everything that you consider a trade secret. It might be something that you limit to only the most important of your trade secrets. The advantage of actually having a stated objective record of what you consider to be your trade secrets is that, unlike in any other two litigations, you would be in a better position to articulate, in the case of a misappropriation, articulate to a court what precisely it is that you are trying to protect and avoid some of that round and round drawn out litigation that we saw in those two examples. Even more important to that is that if you better know what it is that you want to protect, you can better position yourself to protect it. And in this case here, we'll talk about that a little bit more, about how you might go about what strategies courts will be assuming and expecting you to pursue in order to protect your trade secrets. Because if you remember, one of the definitions of a trade, or one of the requirements to qualify yourself for trade secret protection, is that you must take reasonable measures to protect your trade secret to maintain the secrecy. So one of the things you need to do, as I mentioned, you got to know what you need to protect. You certainly want, as with any other policy that governs your organization, you're going to want top-down expressions of the importance of both knowing and protecting the organization's trade secrets. You're going to want to have trainings and policies around why this is important. Stated plainly, if our secrets walk out the door, we will not have a business, perhaps. That we could be seriously jeopardized in our ability to conduct business if our secrets walk out the door. Well, you can implement that in whatever manner works best for your organization, but any business organization is likely to be familiar with the employee policies and trainings around various topics. This could be one of them. Another approach is to, depending on what the secret is, if it's something that's on a computer system, as most things are these days, you restrict access. Not everyone in your organization necessarily needs to have access to everything. I can't tell you how many trade secret litigations Brian and I have seen where someone who had no real business need to get at something within a computer system was able to do it and download an entire customer list, or download purchasing history or pricing history or something like that on the way out the door to a competitor. If you can restrict access, you can keep that from happening, and you can also express to the court that you have taken reasonable measures to protect the secrecy of your products. So consider whether or not your engineering team needs access to all of your sales data. Consider whether or not your sales team needs access to all your engineering data. Other steps you can take, Brian mentioned earlier, confidentiality agreements. That's certainly important. Again, confidentiality, something that you define as confidential in an employment agreement or separate confidentiality agreement, does not necessarily qualify it for trade secret protection, but that is something that you can do. A breach of a confidentiality agreement is a breach of contract that gives rise to a cause of action completely independent of trade secret misappropriation. Non-competition agreements, non-competes. You can utilize those. A lot of employers do, depending on the jurisdiction where you're located, where your employee is located, and where you would seek to enforce a non-competition agreement. Some jurisdictions don't enforce them at all. We would say that in the aggregate, that non-competition agreements are read by courts as narrowly as possible because they restrict people's ability to go earn a living. So we would not want to leave that as your sole basis for protecting your confidential information, your trade secret information, but that is a tool that can be used. There are various data security measures that can be implemented, particularly important now with so many people working remotely. We've had cases where our clients have been able to say, not only has our former employee walked out the door, that we have a record, we had a system flag for unusual download activity. That is a great tool. If there are folks who are taking a large volume of documents off of your system and emailing it to a personal account or downloading them onto a flash drive or something like that, that is something that's a problem. That is something that you should have your system configured to flag, so somebody can reach out to that person and say, hey, what are you doing? You don't want to find out about that after someone has left. When you know someone is leaving, consider whether or not that person needs to continue to have access, particularly if that person is going to go work for a competitor. You should be monitoring that person's system activity, logging that download activity for future reference, so that if you have an issue and you go to your lawyers will have access to that and will be able to show the court that there was an unusual download activity on the way out the door. That's important to getting relief to protecting the trade secret and getting relief from the court to preclude people from using that trade secret once it's exited. And then another thing you can do is once someone has left, maybe don't immediately recycle that person's laptop or company issued phone or what have you. Maybe don't immediately wipe that person's server space if you have dedicated server space. Maybe even if you don't suspect that something nefarious may be afoot, maybe just hold that in place for a while, have some kind of cooling off period so that in the event that something had happened that you just know about, we still have access to the evidence. All of these things have been magnified in our current environment. The Great Resignation which has just had unprecedented employee mobility. All of these things are important in this current environment. All right, I'm still talking. I'm sorry. So, another thing to consider is limiting the risk of misappropriation of trade secrets that would belong to others. So not only do folks depart various organizations, but of course you all are doing hiring as well. And Brian and I have represented businesses on both ends of a trade secret misappropriation suit. We've had to assert claims that our clients' trade secrets have been misappropriated by a competitor. But we've also had to defend businesses against allegations that they hired folks who brought their former employers' trade secrets to our client. And that's a problem as well. And we would suggest that you consider, if you don't do this already, that when you onboard someone or you're considering hiring someone, that you make sure you know whether this person is coming from a competitor. You make sure you know whether this person is subject to some kind of restrictive covenant. And make sure that you have articulated that your expectation is that this person is not bringing anything with him or with her from the prior employer, that this person is being hired for his or her talent, not for something specific, something that could potentially qualify as a trade secret that would belong to the prior employer. There is such a thing as the inevitable disclosure doctrine. And you still see this in litigation. But what that means is that if my employee gets hired by a competitor, and I just don't think there's any way that that employee can work for my competitor without disclosing my trade secrets. An argument I would make to the court is that my trade secrets are going to be inevitably disclosed if that person is allowed to work in the role that the competitor hired that person to work in. And that is a doctrine that is somewhat more constrained. It varies by jurisdiction. It's something that can be argued where we sit currently. It cannot be argued in other jurisdictions. But that is just something to consider when you're onboarding someone as well.
So Eric's gone through in good detail some of the things you can do before you press the litigation button, and things you can do without there being a dispute, that you can go ahead and effectively protect your trade secrets. Hopefully, folks on this call on this presentation do not have to think about the next step, which is whether or not you're going to litigate. You obviously are going to do that if your trade secret or you think a trade secret has been taken from you. And sometimes you have no choice. Sometimes you get sued. And you've gotten sued because you perhaps onboarded an employee that took a trade secret. I had a case, and it's a strange one, but I had a case that was a large case between two very large pharmaceutical companies, whereby the allegation against my client was that the CEO of my client had taken trade secrets through his girlfriend, a mistress, in fact, that was still working at the competitor. So, the in-house team for that client certainly couldn't have seen that case coming. And so sometimes the point is you're going to be in this litigation, whether you like it or not. So you have to go through an analysis early on as to how hard and to what extent you're going to either fight the litigation brought to you or bring that litigation and fight hard. And here are some points that you want to be thinking about when making that analysis. Again, you want to think through, okay, is the trade secret at issue really a trade secret? We've gone over a lot of different points that you need to be thinking about. Again, I go back to those 3 bullet points earlier on in the presentation. But it's a critical question, and one if you're calling Eric or me, that's the first question we're asking you, and we're going to be asking a lot of different questions in connection with that topic. The next thing is harm. Okay, you have to think through. All right, what is the harm here if we allow our trade secret out, and what is the harm being alleged if we got sued that we've caused by virtue of allegedly taking a trade secret? That's an important thing to do, right? I mean, these are all line item cost items, right? So you need to identify what the harm is, and then that leads to the next question, which is the cost. How expensive is it going to be to either defend or prosecute a trade secret case? We can tell you, like any litigation, it's expensive. And I can also tell you that every company has a different business strategy in connection with whether or not they're going to either defend or take on a trade secret case. Oftentimes, plaintiffs will bring trade secret cases, clients will bring trade secret cases with no expectation of getting $1 out of the case, that is a judgment, but rather looking to make sure that the trade secret is in fact protected from disclosure, and use the tools available in litigation to protect and keep protected the trade secret. And that's in particular highlighted by seeking injunctive relief, which we'll talk about in a moment. But so when you think about cost and harm, you need to think dollars and cents, but you also have to think business strategy. And we talk to you about that and walk you through that as we discuss the strategy along, your litigation strategy.
And one point to consider is insurance here. A typical liability policy may very well have an exclusion. So for cases that assert a misappropriation or an infringement of intellectual property. So in that, if you have such a policy with that type of exclusion and you get sued for allegedly misappropriating a trade secret or infringing a patent or what have you, you may be paying that defense cost out of pocket. That's something to be aware of and perhaps consider when you go to renew your insurance coverage.
All right, we're now talking litigation. All right, you've decided to press the litigation button, or you have no choice and you've been sued and you've decided you're going to defend yourself. So we're now going to talk about the tools that are available to you, and we're going to frame this in the context of the what I refer to here as the DTSA, the Defend Trade Secrets Act. Again, that was an act passed in 2016. And there's several things about it that are unique to it that are helpful. The biggest one for us litigation nerds is that it got us access and gives us access for these cases to federal court more easily than we had in before. Why is that important? Generally speaking, and again, this is generally speaking, the judges and the procedures available in federal court are better than they are in state court. And that's important, right? Whoever's deciding your case is arguably the most important person in the room. And so it's important to make sure that person is qualified and knows what they're doing. And typically, federal judges are pretty good on that accord.
I would say that the federal judges also enjoy larger full-time staffs to help them learn the cases and learn the science or the technology behind the alleged trade secret as well.
Yep. So a little data point here is just identifying the amount of cases getting filed, and how many of them have been cases that are alleging a Defend Trade Secrets Act claim. Just highlights that it's a trend that it has increased since its passage, and I expect it'll increase even more. So what are some of the tools available under the Defend Trade Secrets Act? So in addition to federal court access, this is the next one. I'm not going to go through each one of these data points, but I will point out that this is a very potentially effective tool and a new one under the Defend Trade Secrets Act. And that's called, lawyers like these terms, Exparte Seizure. What does that mean? It means you can get in front of a judge on your own without the other side being there and get that judge to order the others, to seize whatever nefarious product is out there. I'll go back to my, the first case under the Defend Trade Secrets Act that went to a jury trial was a case that I was involved in the country. And one of the tools used by the plaintiff in that case was to try to get an ex parte seizure. It was a case, as I mentioned earlier, about fig jam. Our client put out a competing fig jam that was alleged to have taken the plaintiff's recipe to get it out there in the marketplace. And so the plaintiff used the Defend Trade Secrets Act ex parte seizure tool to try to get those products off the shelves. It was not successful. However, it was a tool that was available to even try, which was not available at all under the state law that was that existed prior to and continues to exist, of course, to the DTSA. So ex parte seizure, you go in by yourself without the other side there. You argue to the judge, hey, we got to get this stuff off the shelves. You now have the opportunity. It's a high bar to hit, but you now have the opportunity to get that relief. Here's the more common relief that is available both under state law, but also under the Defend Trade Secrets Act, and that's an injunction. An injunction it basically is a relief you ask for from the court, where you say to the court, hey, they need to stop using my trade secret. You have to order the other side to provide my trade secret back to me. They got to get rid of it. It's threatened. It's a tool. It's not a monetary relief. It is a relief where the court tells the other side to either do something or not to do something. It's intended to prevent, as we note here, actual and threatened misappropriation. You may require affirmative actions to be taken to protect the trade secret. Again, you've got to, you can ask the court to say to the other side, hey, the other side, the defendant, you got to do certain things to protect the plaintiff's trade secret. That's another tool that's available under if you ask for an injunction.
And one thing, sorry, go ahead.
Yeah, go ahead, Eric.
So one thing I want to point out is that under the Defend Trade Secrets Act, and that this is the citation, the 18 U.S.C. 1836 is the citation to the statute. What you cannot do as a plaintiff is get a court to enter an order keeping someone else from being employed. You cannot preclude your competitor from hiring your former employee. What you can do is limit the role of that former employee within your competitor's organization. But those limitations have to be based on evidence of threatened misappropriation. You can't keep someone from working as a salesperson merely because that person had knowledge from your employment. You may, however, be able to limit the breadth of that salesperson's activities within the employ of the competitor.
Yeah, and just one more note I'd make before we go to the next slide. This is the tool that Eric and I, if you give us a call, we're going to talk the most about, or at least one of the first ones we're going to talk about. All right, this one's going to be the one that you really want to focus on, because this is the one that is going to protect your trade secret. We'll talk about dollars a little bit later and getting damages, not money from the other side. But this is what you really are going to be focused on, certainly in the beginning.
Right. And if a litigation, a lawsuit is filed alleging misappropriation of trade secrets, whether you're on offense or whether you're on defense, the activity is really intense on the front end. So you're thinking about the injunction that we just talked about if you're on offense. You're defending against a request for an injunction if you're on defense. And in order to do that, you're thinking about these four factors that you see here: the likelihood of success on the merits, irreparable harm, balance of harms, public interest. Those are the four considerations that a court weighs in deciding whether to grant or decline to grant an injunction in a trade secret situation. So likelihood of success is essentially a mini version of proving your case. So it's a mini version of proving that there was a trade secret, that you checked all of the boxes for a trade secret, that it is secret, that it has value from being secret, you took reasonable measures, and so on. You have to prove that the only way to keep irreparable harm from occurring is to issue an injunction, and so on. Again, that's a heavy lift. It's expensive. It's intense. But frequently, I say here that it might burn hot, but not long. But typically, and I would say even in most cases, that once you get through the injunction phase, the rest of the case tends to fall into place. And they don't, with some very notable exceptions, including the cases that we talked about earlier, they tend to not drag out once you have a certain established parameters around what an employee can and cannot do. We don't necessarily need to hit these other points here, but something to consider if the case proceeds beyond the injunction phase is discovery. You're going to have to prove the trade secret if you're a plaintiff. You're going to try to disprove that and exploit that as a defendant. There will be depositions, there will be exchanges of documents and written discovery. There are tools to help preserve trade secrets in that context, but the trade secret itself will be explored. But again, there will be tools to help preclude that trade secret from becoming public knowledge.
So we've talked about ex parte seizure, going in and getting the nefarious product off the shelf. We've talked about injunction, getting the other side to do what you need them to do to protect your trade secret and stop using it if they are. Now we'll talk about dollars briefly. So you can also, of course, as part of litigation, say to the court, look, I got damaged by virtue of the trade secrets being taken and used by the defendant, and I'm entitled to be compensated for those damages. And this pie chart highlights from 2016 to 2020 the damages that have been awarded at a macro level in different categories during that period of time. You're going to focus on actual loss. How many sales did you actually lose because there was an improperly competing product out there that was using your trade secret? You're going to talk about unjust enrichment or royalty, perhaps. How much money is the other side making or has made that they shouldn't have made because they stole your customer list or they stole your recipe? You get lost profits. You could maybe even get R&D costs associated with the trade secret. The other piece, the statute allows you to double your damages if you can establish that the trade secret was willfully misappropriated, a fancy way of saying willfully taken, intentionally taken from you. The other big piece to this, which is always part of the conversation, is getting your fees paid for. As we mentioned, litigation, for those of you that have been involved in it, know that it's expensive. And the statute allows for, under certain circumstances, for you to get your fees paid for by the other side if you win. And if the other side wins, if you brought the claim in bad faith, then you might be able to get your fees paid for. The fees are available to the plaintiff, however, if, again, you're able to show willful or malicious misappropriation. Again, something was taken from you intentionally. And cumulative. So this is a powerful tool as well for the right case. Oftentimes it's always pled, right? More often than not. but it's a little harder to prove because the standards are a little more heightened than they are for just showing it, a run-of-the-mill misappropriation of trade secret. And this is our last slide. I wanted to just show you that just, again, taking, getting out of the trees and moving to the forest a little bit, just showing you the breakdown by industry since, as of 2020 at least, of the damages, the average damage award by industry. And if you look at that, you see IT by far is the largest, then followed by financials, healthcare, energy, consumer discretionary, telecom services. So that just gives you a little bit of idea of which industries are potentially at most at risk, or at least which ones are being most successful in litigation and obtaining damages. And that's it. So I wanted to thank everybody for joining us, and we're happy to answer any questions that anyone may have.
Looking at the questions here. Yeah, looks like we've answered the questions that have been placed into the Q&A box. So if you have any others, feel free to add them. If not, we can let folks get about their day.
Eric, Brian, great job. You're very clear, cogent presentation. Thank you.
I think we got one question here. Can you please expand on ways to license a trade secret? Eric, do you want to handle that one?
Sure. Well, and actually, this might be something that Jerry wants to talk about too, since Jerry's part of the team that does a lot of work around patents and patent licensing and patent prosecution. So the way the license is, essentially a contract. I think the key difference in licensing a trade secret is maintaining obligations around the secrecy, and which is different than licensing a patent. Because if by virtue of someone else utilizing your secret, it spreads, it's disclosed in a way that it ceases becoming a secret, it ceases to be a secret and becomes disseminated, then it's not going to be protectable at all. Jerry, do you have any thoughts on it?
Yeah, that's a great question. A lot of times you'll have a non-disclosure agreement between a small entity, a startup maybe. They've figured out a new way to make microbubble, for example, for using an ultrasound cardiac pathology diagnosis. And they have a non-disclosure agreement with a larger company. And the purpose of the agreement is to disseminate this proprietary information solely for purposes of doing a business deal. 10 months later, they get kicked to the curb, and you find out 2 years later that your particular invention, your trade secrets were used as a benchmark for them to build a better mousetrap. So these license agreements are prepared, whether it's a non-disclosure agreement or a contract, as Eric said, you'll have language in there protecting patents and know-how. And the know-how is your trade secret. And as Eric and Brian have hammered continually throughout the presentation, you have to protect it. So if you have such a situation where you need to prepare a contract to protect the trade secret, call Eric and Brian and or any of the other attorneys, and we're happy to help you.
Yeah, at the end of the slide, we've got our contact information, so feel free to reach out.
All right, folks, I think that'll do. Thank you for your participation, your attendance, and I hope it was helpful. Good day.
Thank you. Well done. Thank you.
Thanks, everyone.